Now, I'm all for protests and expressing yourself, but there's a bill before Parliament which means you're going to have to be very, very careful at any of these types of rallies. That bill I'm talking about is this absolute monster, the Australian Security Intelligence Organisation Amendment Bill. This is the end part of the explanatory memorandum introduced by the Honorary Peter Dutton. 726 paragraphs just in the explanatory memorandum. That's not the legislation itself. If I scroll up, you can just see how much is included in this just so-called amendment. But it's a monster. It's got a lot of, what would you call, tricks and traps that aren't even hidden. So I'll get into a couple of those now, rather than only in relation to terrorism offences. So the first thing that you need to notice is that these questioning warrants are now going to be used for politically motivated violence. Now, under terrorism, they have all these laws that they say, oh, we're just trying to prevent terrorism, just preemptive enforcement. And that's what this is. This isn't about, say, some violence has happened and then they're going to bring you in for questioning, because they can do that anyway because a crime has been committed. Now, these questioning warrants are so they can drag people who are organising political protests to be dragged in before there's any protests or violence, which means, therefore, there won't be any violence, but they will still have the effect of taking into custody people associated with political protests. The dot point above that is replacing the existing detention framework with a more limited apprehension framework. Okay, sounds more limited, but to ensure attendance during questioning and to prevent contact with others. So while it says it's more limited, adding more powers they can use against population. And this one's pretty dangerous. Enabling the Attorney General to issue questioning warrants directly, removing the role of the issuing authority, which I think would have to be a court. But not only that, enabling the AGO to request the Attorney General to issue questioning warrants orally in an emergency. Well, everything's going to be an emergency, and all of them are going to be issued orally, particularly the ones that they don't want anything written down about. Providing power for a police officer to conduct a search of a person who is apprehended in connection with a questioning warrant, not necessarily the subject, but just in connection, and the ability to seize dangerous items and items that could be used to communicate the existence of the warrant, i.e. your phone, and escape from custody, with the additional ability to seize items of intelligence relevant to the questioning matter when authorised by the Attorney General. In other words, they could search and seize anything that you've got, and they would certainly take anything that would be useful to your rights. And again here, introducing screening measures and person searches for people attending the questioning, either as a subject of the questioning warrant or others involved in the questioning process, such as, but they can say anyone's involved, so they can just search anybody. And the ability of a police officer to retain any dangerous items and communication devices. They really want to start taking people's phones from them. They want you to use them as an identification, and they can track you, but they want to be able to take it off you at any time to ensure safety of those involved in questioning and the integrity of the questioning. They don't want what they're saying and questions being recorded. Now, this starts off strengthening the right to legal representation during questioning while retaining the ability to prevent contact with specific lawyers due to security concerns and to remove a lawyer who is unduly disruptive during questioning, such as defending their client's rights, and introducing the ability of the independent prescribed authority to appoint a lawyer for the subject of a questioning warrant. In other words, they choose your lawyer, who pretty much is going to be on their side, not yours. Listen to this as I read it out. This one's really important. Enabling a questioning warrant to be executed following the laying of charges against the person who is the subject of a questioning warrant, and where charges against the person are likely, and allow for questioning to cover matters that are the subject of those charges, the appropriate protections in relation to the person's fair trial. In other words, once you've been charged, you have the right to remain silent. You don't have to do anything that will incriminate you. Well, under this amendment to the ASIO Act, they want that gone. They want to be able to force you to answer questions and therefore take away your ability to have a fair trial. Now, remember, this only applied to terrorism before, but now it's to politically motivated protests. So there was an existing 28-day limit for questioning warrant to be enforced. So they can apprehend you, and they used to be able to hold a terrorist for 28 days, but they can now hold a protest organiser, a political organiser of a protest for questioning in regards to, we think there's going to be violence. So you can imagine it, 10 days before a protest is scheduled to go ahead, they would identify who the organisers are. It could be 5, 10, 20, 30. Bring them all in, hold them, for 28 days, and then the protest virtually can't go ahead. And that's what this bill is all about. It's about removing people's ability to peacefully protest against the government and the parliament and the bankers, in effect. Now onto the surveillance part. This amends the Surveillance Device Framework and ASIO Act to promote increased ability, operational agility, mitigate risk, blah, blah, blah. Enable ASIO to use tracking devices with internal authorization in certain circumstances rather than requiring a warrant. Okay, so they need a warrant to install a tracking device. Well, this bill enables them to track you without a warrant, track anybody. Clarifying that the surveillance device framework is permissive and does not require ASIO to obtain a warrant where conduct will otherwise be unlawful. Updating the definition of tracking device and effectively modernising ASIO's capability. Deep within the other 740 parts to this explanatory memorandum, they wanted to redefine a tracking device as any other thing. So that could be anything. That could be a chip that they insert into you, and they could do it without requiring a warrant or any kind of legal, permission. Now, this is where it gets laughable. It says this bill is compatible with human rights and freedoms, but later on it even admits that it isn't. Oh, there's that part where a tracking device is any other thing. So, like I said, a chip they can insert into you. Okay, I'm going to end this one soon because it's only a truncated version, but this is really the most important part. This bill engages the following human rights. Now, what they mean by engages, if it had nothing to do with human rights, it wouldn't even be here. And they're using the word engage instead of breach because that's what these things do. When your right to a fair trial is taken away because they can force you to incriminate yourself, those rights are protected under these treaties. Because what happened was Australia signed the International Covenant on Civil Political Rights, and which this thing breaches, and contravention of torture and degrading treatment and punishment. Now, Article 9 of the ICCPR, that treaty, the right to freedom from arbitrary detention and arrest, and the right to liberty and security of the person, which is you're losing your liberty and you're being detained. It breaches the right to freedom of movement because they're apprehending you, as well as the right to a fair trial, which they've clearly stated that's what this is going to do, stop you having that right. How about this one? The right to protection against arbitrary and unlawful interference with one's privacy or home. Article 7, they're going to breach that. Deep within the 740 parts of this explanatory memorandum. And finish off the right to freedom of expression, the right to freedom of association, the right of the child to have the best interest as primary consideration. They're going to take children away from you. The right to support and exercise legal capacity, they have people with disabilities, but they're the two important ones there. They're going to take away the right to freedom of expression and the right to freedom of association. They even say this in explanatory memorandum. The politicians that are going to vote on this should be reading all this, and this just cannot go through. Now, it's in here where they start to use complicated wordplay and convolutions to try and make out like, well, we're only engaging those rights that people have under these treaties. But when you read some of what they say, it's number 23 here, Article 9, rather than prohibits detention, only detention that is arbitrary is prohibited. So they're making it subjective. See how they use these words? But the intention is that you're not detained unless you've committed a crime, and you haven't in this regard. So that's how your freedom of movement, and they're taking away, and freedom of expression has all been taken away, your liberties and what you're allowed to say. So that's what this bill is there to do. Here we go. The power to apprehend is distinct from detention. Why? How? You're stuck. They're holding you in a place. Apprehension or detention, the effect is the same thing. They're using words to try and fool these members of parliament and with all of their committee meetings and, oh, it's okay, you can vote for this. But if they're thinking clearly, any parliamentarian other than, well, I guess a lot of them are paid for by the banks from the major political parties, but hopefully the independents won't let this thing go through. And here's this bullshit justification for apprehending someone who they haven't got any evidence. See, this used to be for terror, remember? And they could maybe somehow, plant or find something that you're going to bomb something. But all you want to do is organise a political protest that they're now saying, oh, it's going to turn violent, so therefore we need to question you. That's what this is all about. Now, that is just such a big stretch from, planting a bomb to organising people to go down and talk, and then suddenly they're going to turn violent. They need to prove that you had plans for violence, but then that's what this questioning warrant is about. But it's about disrupting the protest organisations and the process. So, look, I'm going to end it now.